Is anybody in there? Can you hear me now?
I call to order the meeting of the Michigan Board of State Canvassers. Director Brader, has the meeting been properly noticed?
Yes.
Thank you. And James Gallant has to speak. Gallant, you have 1 minute.
What?
Gallant? We have.
I can hear him. I can hear him
Mr.
talking.
Gallant?
Hello, can you hear me?
Oh, yes, I can hear you now. You have 1 minute. Mr. Gallant, we can't hear you. Okay, Mr. Gallant, we're going to go ahead with our meeting and we will call you later on in our agenda, which will just be a short time, but we can't hear you now.
I'm trying to speak. You're all choppy. What happened? Are you hearing me now?
Okay, I can hear you now.
Okay.
Okay.
And,
so
and
you have-
1 minute, when did you change the rule for 1 minute? It was 3 minutes. Now, come on. I see Dana Nessel, James Gallant, Marquette County. These are my opinions. Can you hear me?
Changed it to 1 minute.
Change it when? When did you change it?
When
When did you vote on that?
of time that we allow for public comment is.
I'm supposed to get public comment on every agenda item. I want every agenda item and I want the 3 minutes. Can I start?
With us.
Can I start?
How much time you have?
What's that?
I said you're using up your time by arguing.
I'm not. Guess what? Ask Dana Nessel to investigate you and your parliamentary procedure for certification fraud in the 2020 presidential election because you, sir, that's Marquette County certified with only 3 members present against the Constitution, Article 2, Section 7, Paragraph 2. And the State Board of Canvassers wrongfully made 2 motions on November 23rd, 2020, without a second by consensus. You are not following the common law parliamentary procedure. Please schedule a public meeting. And what are you changing the rules with no? What is this? We got common law parliamentary procedure in America, and you are the ones that committed fraud in the 2020 presidential election by certifying the election when Marquette County only had 3 members present in direct contradiction, majority of one party on a canvassing board. And you certified that, and you didn't even post this meeting properly because it's not posted in the front window of the Austin building where you're supposed to post those. Sorry.
Thank you, Mr. Gallant.
Yeah. Guess what? Guess what? I'll be back. Give me more time on every agenda item.
The next item on the agenda is consideration of the meeting minutes for the March 18th, 2020.
Yeah, but I thought you were going to give me some more minutes, some more time, Madam Chair. How about you give me the consideration under the Americans with Disabilities Act for all of the folks?
You turn him off? As I said, then the next item is consideration of meeting minutes for the March 18th, 2024 meeting. Do we have a motion?
Support.
The interpreter can't hear who's speaking in the background, please.
Yeah, I think that's me talking in the background, okay? I'm still waiting for my public comment time, and I'm waiting for you to make sure that my citizens are being protected under the elections laws of the state of Michigan, which you approved.
All in favor? Aye.
Aye.
Okay, the motion carries. Is he?
And I'll just interrupt for 1 second, just to note that member or Vice Chair Hauskamp moved for that, and then member Daunt seconded. Thank you.
Okay, and I will note for the record that member Bradshaw was unable to attend today. The next item on the agenda is recording of the results of the special general election for the office of State Representative 25th District.
Thank you,
Director
Chair
Brader.
Gower. Yeah, thank you, Chair Gower. So this is the district that is wholly within Wayne County, District 25. So this has already been certified at the county level by the County Board of Canvassers in Wayne County. However, the Board of State Canvassers is recording the result of that election. First, I would just like to convey my appreciation for both the municipal and county clerks in Wayne County and all the election workers who were involved in both the special election on April 16th as well as the special primary in January. This was certainly a significant challenge for all of those workers and election officials, having 2 additional election dates around the presidential primary and also with a May election coming up in some places. So a substantial accomplishment for all of them to get this done. That said, the Wayne County Board of Canvassers did certify the results of this election. The 2 candidates of the major parties received a total of 10,689 votes. And Peter Hertzberg, Democrat, was the winning candidate with 6,373 votes.
We are recording. Do we need a motion to record this? Yes, okay. Do we have a motion?
Indeed, Madam Chair, I move that the board record the results of the April 16, 2024 special election for the office of State Representative 25th District as certified by the Wayne County Board of Canvassers on April 24th, 2024.
All in favor?
Aye.
Motion carries. The next item is canvass and certification of the April 16th, 2024 special general election for the office of State Representative 13th District.
Thank you, Chair Gerwitz. So this is a election that the Board of State Canvassers is certifying because the 13th District is partially in Wayne County and partially in Macomb County. Again, in addition to Wayne, I would also just like to commend the Macomb County Clerk's Office and local clerks in Macomb County, as well as election workers there. Again, these 2 additional election dates were certainly a significant undertaking, and they all did a great job fitting this in. So in this election, Mai Zhang, the Democratic candidate, was the winning candidate. She received 4,467 votes in Macomb County and 1,274 votes in Wayne County for a total of 5,741. And Ronald Singer, the Republican, received 2,950 votes in Macomb County and 57 votes in Wayne County for a total of 3,007.
We have a motion.
Based on an examination of the returns received by the Secretary of State for the April 16th, 2024 special general election, I move that the Board of State Canvassers certify that the attached report is a true statement of the votes cast at the special general for the office certified by this board. I further move that the Board of State Canvassers authorize the staff of the Bureau of Elections to represent the board in any recount of votes cast by the April 16th, 2024 special election.
Support.
All in favor? Aye. Motion carries. The next item on our agenda is consideration of the challenge deadline for sampled petitions. Either Mr. Fracassi or Director Brader.
One more thing, can I just also note for the record that the time of certification was 10:09 a.m. Thank you.
Oh, okay.
Thank you, Chair Gerwitz. So I think with your permission, I will just use this as an opportunity to talk a little bit about the process that we're going to be following to review both candidate affidavits of identity as well as nominating petitions that will go before the board. And then I'll of course also explain why we're presenting this motion to the board regarding the challenge deadline for some petitions. So April 23rd, Tuesday, was the filing deadline for most offices, and that involved candidates filing either with the Bureau of Elections, Department of State at the state level, or for many other offices filing at the county level. We are now prior to the ballot certification deadline in early June, we are embarking on a two-tiered process or a sort of two-branch process to review candidate eligibility for the ballot or qualification for the ballot. The first aspect of that is the review of the candidate's filings, which are their affidavits of identity. Those are reviewed and determined to be valid by the filing official, which in our case is the Secretary of State. So the Secretary of State, Bureau of Elections, will be making determinations as to whether the affidavits of identity are sufficient to qualify them for the ballot. So that is a Secretary of State decision rather than a Board of State Canvassers decision. We do sometimes hear from folks at these meetings that want to raise issues related to affidavits of identity, but those are not within the purview of the Board of State Canvassers. Of course, the Bureau of Elections, Secretary of State are not the final word on this, and people can always appeal those decisions to court, which they often do, but it doesn't go through the Board of State Canvassers. So we're going to be reviewing all of those affidavits of identity to determine whether they meet the requirements. The issue that usually gets the most attention is the requirement that they certify that they have filed all reports and paid all fees owed under the Michigan Campaign Finance Act. So that involves a review of their campaign finance status for past or current or past, I suppose, campaign committees, which might be filed with the state if there were state level campaign finance filings, or they may have been filed with the county. So we'll be coordinating with the counties to determine all of that. And that's a pretty extensive process. And we'll be doing that over the next few weeks. We'll also, of course, be looking for other issues such as registration status and other requirements that they need to meet in order to qualify for the ballot. But when we bring to you the candidate listing and the nominating petitions to review at your meeting to certify candidates to the ballot, anybody who we already disqualified because of an affidavit of identity issue will not be on that list. Of course, again, if they disagree with us, they can always sue. So the other side of that, which is more pertinent to the Board of State Canvassers, is the review of the nominating petitions. So this will primarily be U.S. representative in Congress, U.S. Senate, and also judicial candidates. State House and State Senate candidates can file nominating petitions, but the vast majority of those will do a filing fee. So I think there's only perhaps one or two of those candidates that submitted nominating petitions. So what we are doing now at the same time is also reviewing the nominating petitions and the signatures associated with those nominating petitions for all candidates that were required to file those. For most of the petitions we're reviewing, we are following a process that was pretty similar to what we have done in past elections. We've already talked about that earlier in this election cycle at multiple meetings about some of the changes and improvements we've made to the review process. But again, it will involve a face review. And of course, people can challenge the form or the formal issues or signature issues on any of those petitions when we're talking about things like U.S. representative in Congress and judicial candidates. And so for those, the sort of the first step of that is we have made those available. All of those petitions have been made available. And under the board's process, those who wish to challenge any of those petitions have 7 calendar days from the filing deadline of April 23rd to submit their challenges to us, which would be April 30th. So we are reviewing those. We're doing the face review. We're going through the petitions, and then we'll also consider the challenges we receive by April 30th. And the candidates will have an opportunity to reply or respond to those challenges. And then we will be presenting our recommendations to you at the board meeting. And I think May 31st is the scheduled date for that. So that's most of them. However, the biggest change we made for this year is the board has approved that we use random sampling for statewide candidates. So in this case, that's U.S. Senate. And so there's 8 U.S. Senate candidates who are required to submit a minimum of 30,000 signatures. And we are drawing a sample of 7. That's correct, right? 30,000. Oh yeah, that's the max that can submit. 15 is the minimum. Yeah. Sorry. Yeah, at least 15,000 valid signatures with a maximum of 30,000 signatures to be submitted. And so we're reviewing we're drawing a 750 signature sample for all of those and reviewing that sample to determine, based on the sample, whether they have enough signatures to qualify. That will ultimately be the board's decision. We have already drawn and released those samples for each of the 8 candidates. That again is a major time improvement from what we've been able to do in past samples for a lot of the reasons we talked about at previous meetings. So within 2 days, we were able to draw and release those samples for 8 different candidates. Whereas, under the previous procedures we used for ballot initiatives and such, it would typically take much longer than that. So that's definitely already a time improvement that we've recognized. We did again release those samples yesterday, so 2 days after April 23rd. So I will now come to the point of this recommended motion, which is that whereas for the other candidates like U.S. Representative in Congress, where the 7 days would run from the filing deadline, at which point they could request and then receive very quickly the copies of the petitions. When it comes to the U.S. Senate candidates, we didn't have the sample available until yesterday. So we think it makes sense to, or the board should at least consider having that 7 calendar days run from the day we made the samples available, which is yesterday. So therefore it would be, I believe, May 2nd, as opposed to April 30th for the other candidates. And this motion would affect that change.
And do I understand that that extension of time would be only for the statewide candidates whose petitions are sampled under a new procedure?
That is correct.
Any questions?
Not related to the motion at issue. I can make the motion, then ask the questions following.
Yeah.
You have any?
Sure. Pursuant to MCL 168.552, I move the Board of State Canvassers extend the challenge deadline for sampled petitions to 7 calendar days from the date the samples were made available.
Support.
All in favor?
Aye.
Motion carries. Do you have some questions?
Just a couple of kind of housekeeping type questions that folks have asked me. One of them is related to the affidavit of identity and the rejection. If they sue, if somebody's rejected and they sue, is it expected that they would have an answer in time to have that clarified and then if necessary added to our agenda for May 31st? Or would there potentially be a need to come back and handle any that were rejected through that measure?
So, yeah, I mean, I think that would depend mostly on the timing of the courts. Our goal would be to make our determinations on the affidavits of identity in time to give anybody who is disqualified, or also, I suppose, anybody who is qualified and there's somebody else who thought they should have been disqualified, time to bring something else that they would like to bring to our attention. But then if they don't get the outcome they want from us, they would have time to file suit in court. So we're trying to give a cushion of at least a few days to allow that all to happen. However, a court may not think it's necessary to make a decision prior to this board's meeting to certify the candidates. And there could also be appeals. So I think in the event that a court makes a change following this board's meeting, I think it would be within the court's, I mean, I guess it's really more of a legal question, but I think and so I would defer to Eric on this, but I think it would be within a court's discretion to either order the board to put them on the ballot and reconvene, or I suppose the court could probably just do it on their own. I don't know what the past practice has typically been on that. I don't know, Eric, do you have anything to add on that?
I'm sorry, could you?
Yeah. So the question is basically like, suppose that the Secretary of State disqualifies a candidate based on an affidavit of identity. And that the candidate then challenges that decision and the court reverses the Secretary of State. But the timing of that is after the Board of State Canvassers meets to certify candidates on May 31st. I guess, like, what are the question I think is, what are the possible scenarios then for what the board would have to do or what the court would do directly to put that person on the ballot?
Well, I think in large measure, it would depend on the language of the order and who the parties were in the lawsuit. Presumably, the candidates seeking to be placed in the ballot would frame their claims in such a way as to make sure that they could obtain the relief that they're looking for. Ultimately, if the court orders that a candidate be placed on the ballot, that's the relief that they're looking for.
So you're saying that we would not have to have another meeting to put the candidate on the ballot? I think
Everyone's
that-
favorite answer from their lawyer is it depends, but yeah,
I think that was the question, right?
Yeah.
Did-
That's
Yeah.
answers the general understanding. It was more of a timing
Yeah.
issue.
I mean, this could also, of course, happen with nominating petitions, right? So that the board can make a decision on a nominating petition, which could also be challenged, and then a court would have basically the same situation where they would, if they were reversing the decision of the board, then they would have to, there would be the same question about how that relief actually gets effectuated, whether the court says, board, come back together and do this, or the court just puts them on.
I know that on the ballot questions where the court reversed the board's decision, we met again to implement the court's order, right? To do as directed.
I'm sorry. I think the distinguishing factor is who the court is saying was wrong. If it was the secretary's decision, then it wouldn't necessarily be, this board being a party to the lawsuit. So it depends on how the case is structured, how the case is framed, and what the relief they're looking for is.
But the secretary's decision is one that we have to rely upon in order to
Correct.
either certify or not certify. So it's it's a preliminary step. So I guess in responding, as you would do, Mr. Grill, in responding to any challenge to the secretary's decision or to ours, you would be able to request that the court direct the name of the candidate be placed on the ballot, whether as opposed to asking the court to direct that the board take some action.
This is the difficulty with, playing out hypothetical lawsuits that we don't have in front of us. But ideally, what I would say is they want to file that lawsuit against the secretary before the board meets so they can have that determination before this board makes its decision. If they're after that, then we're trying to go back and unring the bell, and that, latches arguments come into play, timing arguments come into play. But again, I guess it very much depends on the facts and circumstances of the case.
Yeah, and it depends on the court. Right.
Well, and to add to that, the court's business, the court's job is not to determine somebody being on the ballot or not. They may vote, they may rule that that person is entitled to be on the ballot, but that would still have to come back here for the light switch to be turned on or off, right? I mean, I'm listening to what you're saying, but on the,
So if the argument is, if I understand the scenario correctly, the argument would be that the Secretary of State has made a determination that a candidate is ineligible and therefore this decision doesn't get to the board. I think at that point, it would be incumbent upon that candidate to act with due haste to get some type of relief from the court before the board meeting so they could be heard and determined by this board. If that didn't happen for some reason, I think there would be at least a colorable latches argument to say they've missed their opportunity to have this board decide and determine their candidacy for that election. But we're way cart before the horse in this circumstance because I don't have any of the facts or circumstances that would bear on that type of situation and whether that argument would apply or not.
no, I hear what you're saying. That makes sense.
But
Right.
if the affidavit of identity is determined to be defective, then we don't make a determination about whether the candidate had sufficient signatures. Right?
Correct.
So if there were a judicial determination that the affidavit was good, then we would have to make an additional determination.
Well, and that's why I say again, that candidate would want to get that determination from the
Right,
court
but
in
the-
advance of the deadline for this board to make its determination.
Right, so the question though is that a circumstance when the board would have to, if it had not made that determination prior to our meeting, the board would have to meet again to make the determination about the sufficiency and validity of the signatures.
Again, it depends and maybe, is the best I could say at this time.
Well, and just to be fair, I'm asking you the question because what we say here is public record. And so I guess I'm asking you the question also as a fire break to not encourage something that goes out through the airwaves saying, wow, lower courts are, if you don't like what, if you want your candidate on, just go to the lower court.
Well,
I'm phrasing that the wrong way, but you get the gist of what I'm saying.
Well, I don't think I'm suggesting that anyone just say, go to the court and
No, I don't think you are.
I did not intend for that to be that confusing. I apologize.
We got to look at your notes beforehand.
Clarifying, not confusing.
Yes. The second question is related to the sample and it's with the statewide candidates and previously with like initiative petitions and things like that, there was that two-step process. And folks have asked me, okay, well, if somebody gets rejected really closely on the sample, they don't draw another sample. Their recourse, and I've told them this, the recourse at that point would be to file suit in court. That was their remedy, correct? Aside from the attempt to rehab and things like that.
Yeah, I mean, so of course they could first make their case before the board. And, if they disagree with determination or staff recommendations on the validity of signatures within the sample, they could of course bring this forward. But yes, there's not a second larger draw in this process. I will say that we're already starting with a much higher percentage of the petition in the sample because we're talking about 750 signatures out of 15,000 minimum. Versus with a statewide in the past, the first draw was usually about 500 out of about 500,000. But having said that, yes, if they just ultimately, if they bring their issue before the board and the board determines that they have not gotten enough signatures based on the sample, then they could challenge that in court.
Just wanted to confirm that what I was saying was correct. So thank you.
Any further questions? Okay, the next item in our agenda is to consider whether any other business is presented. Do we have? No other business is being presented, so it is, I believe, time for us to adjourn at 10:28.